please stand for the jurors? Y'all can take your seats as you come in. Jurors in the box. You may be seated.
Thank you. Good morning to everyone. Good Tuesday morning to the jurors. Madam Clerk is going to take your attendance, make sure we have the correct people reporting, and then we'll get started.
When I call your number, just say here. Number 2.
Here.
Number 4.
Here.
Number 10.
Here.
Number 18.
Here.
Number 23. Here. Number 24.
Here.
Number 27.
Here.
Number 28. Here. Number 29.
Here.
Number 31.
Here.
Number 33.
Here.
Number 35.
Here.
Number 37.
Here.
Number 38.
Here. Thank you very much. As we closed yesterday with a reminder not to discuss this case, research this case, I would just want to make sure that we all abide by that. Are there anything or any issues that anyone needs to report? Okay. Wonderful. And again, we see all the camera and media here today, but I want to assure you, you all will not be recorded, nor your faces, nor your names released to the press and to the internet and to the world. So I just want to give you that assurance. So today we're going to start. I'm going to give you some instructions, and then the attorneys are going to have opening statements. So the order of the trial is in 4 stages. There are opening statements, presentation of the evidence, instructions of law, and final argument, closing arguments. And so first, the Commonwealth's attorney may make an opening statement outlining their case. The defendant's attorneys may also make an opening statement outlining their case. In their opening statements, the lawyers will tell you what they expect the evidence to be. This should help you understand the evidence as it is presented later through the witnesses, and to make you aware of any conflicts or differences that might arise in the testimony. What the lawyers say in opening statements is not evidence, and you must not consider it as evidence. Neither attorney is required to make an opening statement. After opening statements, the Commonwealth will introduce evidence, and at the conclusion of the Commonwealth's case, the defendant has the right to introduce evidence. When the defendant rests their case, the Commonwealth may introduce rebuttal evidence. At the conclusion of all the evidence, I will give further instructions on the law, which is to be applied in this specific case, after which the lawyers will make their closing arguments. In their closing arguments, the lawyers will refer to testimony and other evidence that you have heard. But again, what they say in closing arguments is not itself evidence. Their statements are only their recollection of what the evidence in the case was. It is your collective recollection as the jurors as of what the evidence in the case is, which governs your deliberations. After closing arguments, you will retire, select a presiding juror, which is what we call the foreperson, deliberate, and arrive at your verdict. You must not be influenced in any degree by any personal feelings of sympathy for or bias against any party to this case, for each party is entitled to fair and impartial consideration. The law applicable to this case will be given to you in these instructions and in other instructions I will give at the conclusion of the case. It is your duty as jurors and part of your oath as jurors that you will follow all such instructions. It is also your duty to determine the facts of this case from the evidence and reasonable inferences arising from the evidence. But in doing so, you must not engage in guesswork or speculation. The evidence that you are to consider consists of the testimony of witnesses and any exhibits entered into evidence. The admission of evidence in court is governed by rules of evidence that have been developed over the years. The purpose of the rules of evidence is to protect the fairness and the accuracy of the fact-finding process in which you are engaged. From time to time during the trial, it may be the duty of an attorney to object to what is being offered into evidence. Please do not hold it against the attorney who is making the objection. They are not trying to hide anything from you. Instead, they are simply trying to see that the rules of evidence are followed in this case. It is my duty as the judge to rule on those objections and determine whether you can consider certain evidence. Therefore, you must not consider any evidence to which I sustain an objection or which I direct you to disregard. If an objection is overruled, then you may consider that evidence together with all of the evidence in the case. It is important to keep in mind that no statement or ruling or remark or gesture that I might make during this trial is intended to indicate to you my opinion of the facts of this case. Let me give you an example. My focused, concentrating face has a frown. I don't do it intentionally, so don't think I'm upset, mad, or scowling. I'm just, as kids say, locked in. Okay? So, and nothing that I do should influence your decision. You are to determine the facts of this case. In this determination, you alone decide the believability of the evidence, its weight, and its value. A good deal of evidence that you will hear in this case will be in the form of testimony and witnesses. In taking into account the weight and value that you choose to give the testimony of any witness, you may consider their attitude, appearance, and behavior, the interest of the witness in the outcome of the case, the relation of the witness to any party, the inclination of the witness to speak truthfully or not, the probability or improbability of the witness's testimony, and all other facts and circumstances and evidence. In sum, you may give the testimony of any witness just such weight and value that you determine it is entitled to receive. Until this case is submitted to you for your deliberations, it is very important that you do not discuss the case with each other, the parties, the witnesses, or any spectators, or remain within hearing of anyone who is discussing the case during any break or recess. This includes discussing the case in person, by phone, by other social media means, email, Facebook, Twitter, or any kind of website or blogging. If you are approached by anyone concerning your jury service, you should make that fact known to the sheriff or to the court. You may not go to the scene or make any independent investigation or receive any information about the case from radio, television, newspapers, or social media. Once your deliberations commence, then you must discuss the case only in the jury room when all of the jury members are present. You are to decide this case solely on the evidence presented in this courtroom and not on the basis of anything anyone who hasn't heard the evidence may think about this case. If you are asked or approached in any way about your jury service or anything about this case prior to rendering a verdict, again, you have been ordered not to discuss it, and you should report that contact to the court as soon as possible. Do not attempt at any time prior to the conclusion of this case to research any fact, issue, or law related to this case, whether by discussion with others, by research in the library or on the internet, or by any other means or source. You must not use internet maps, websites, blogs, or any other program or device to search for information about the case, the law that applies in the case, or the people involved in the case. Your sworn duty is to decide the case solely and wholly on the evidence presented in this courtroom. I will expect you to inform me if you become aware of another juror's violations of these instructions. You are to keep an open mind. Do not decide any issue in the case until it is submitted to you for your deliberations at the conclusion of all the evidence and after you have received the complete instructions of law. Just prior to your deliberations, you will be given final instructions regarding your selection of a foreperson, how to conduct deliberations, and the forms for your verdict. Regarding note-taking, if you would like to take notes during the trial, you may do so. On the other hand, you are not required to take notes. You can make your own decision about this, and if you do decide to take notes, be careful not to be so involved in the note-taking that you are distracted from the ongoing proceedings. Your notes should only be used as an aid to your memory. Please do not give precedence to your notes over your independent recollection of the evidence. You will notice that we do have a court reporter making a record of this trial. We will not have typewritten transcripts of this record available for your use in reaching a decision. In addition, no testimony is able to be read back to you during your deliberations. So please keep that in mind in deciding whether or not you will take any notes. At the end of each day, the bailiff will collect your notepads and returns them to you in the morning. At the end of the trial, your notes will be destroyed. The faithful and proper performance by you of your duty is vital to the administration of justice. On behalf of the court and the parties, we appreciate you giving your complete attention to the case as it is presented. Would the defendant like to enter a plea in front of the jury?
Your Honor, she is entering a plea of not guilty.
Okay. So again, Ms. Parker has entered the plea of not guilty, and we are now ready for opening statements. Would the Commonwealth like to give an opening statement?
Yes, Your Honor. Thank you.
Please approach.
On January 6th of 2023, at Richneck Elementary here in Newport News, there was one and only one person who had both the authority to take action in a crisis and the knowledge that a crisis was underway. My name is Josh Jenkins. I am the Commonwealth's attorney assigned to prosecute this case. I'm assisted by my paralegal at counsel table, Megan May. And I thank all of you, as the judge has said, for your service. I know it is inconvenient to be a juror, but this case is important to all involved. And I thank you for doing your duty, and I know that you will. On January 6th of 2023, parents of children who went to Richneck Elementary and the children themselves woke up to a normal day. They packed lunches, got on the school bus, got in their cars. One walked to school that you'll hear from. And to them, nothing was different that day. And as the parents watched their children, backpacks in tow, walk into that building, those parents entrusted the care of those children to that school. They had a promise that when I bring my child into school, the school will keep them safe. But the evidence will show you that that's not exactly what happened. I understand, and perhaps you understand, that in this incident a teacher was shot. That is a horrific tragedy, and I do feel for Ms. Zwerner. But this case is not about Ms. Zwerner. This case is about the children who lived through this event in Ms. Zwerner's classroom, 20 of them. That's what this case is about. You will hear from that teacher because she witnessed the events, but she is a witness. The victim of this crime are the children. The defendant, Dr. Ebony Parker, was the assistant principal at Richneck Elementary at the time. She was the person who was paid to take care of those children. And around 11:40 a.m., Ms. Zwerner had seen a particular child who you will learn has a long history. A long history of discipline issues of which Dr. Parker was already aware well before January 6th of 2023. But Ms. Werner observed something about this student that worried her. You're going to hear from her, and you're going to hear what that concern was. And then she's going to tell you that she went to Dr. Parker and warned her that this child, who we refer to as JT, was in a violent mood. You'll hear that she said, "I don't know what I'm going to do if he hits me." That is the knowledge that Dr. Parker had of the history of JT, that and more. But at 11:45 a.m., Ms. Werner walks in, tells Dr. Parker that JT is in a violent mood, and Dr. Parker does not respond to her, stares at her blankly for just a moment, and then returns to her work in her office. The warning ignored. You're going to hear that this child's past means that no warning should be ignored. Because you're going to hear from a teacher that taught JT the year before. You're going to hear about the violence that that teacher experienced at the hands of a kindergarten. And you're going to hear about the report that that teacher made to Dr. Parker in that year. And that Dr. Parker's response was blank stare, look back down, do nothing. The same response she had at 11:45 a.m. on January 6, 2023. But that warning was not the only warning. At 12:20, a reading specialist tells Dr. Parker that she thinks maybe JT has a firearm. She says maybe it's a toy, maybe it's real, I don't know. She thinks JT has a firearm. She says, "I'm going to search his backpack." Dr. Parker really doesn't reply to her, but she goes and searches the backpack. Doesn't find anything in the backpack. Meanwhile, there are some concerning observations that are happening on the playground with JT. And you'll learn why teachers and counselors then come to expect that JT has taken that firearm out of his bag and put it into his coat and is carrying it around on a playground full of elementary age students at Richneck Elementary School. You're going to hear that he showed it to another brave student, who then reported, young RR reported exactly what he had seen to a teacher. He was terrified, understandably shaken, crying when he reported what he'd seen. At 12:30, that reading specialist goes back to Dr. Parker and says, "I think he has the gun in his jacket." Do nothing. His mom will be here soon, she says. I can only imagine how that made RR feel. But around 1 p.m., a counselor goes to Dr. Parker and says, "I want to search the child. Can I search him? His person?" She says, "No. Mom will be here soon." For over an hour, multiple people went to Dr. Parker and told her there was an armed child at an elementary school running around with, interacting with, children in the classroom, children on the playground, children in the hallways. Multiple warnings brought directly to her. She says, "Do nothing." Does she say search the child? No. Does she say call the police, or does she call the police? No. Does she remove the child from the classroom and separate it? No. She didn't even get up from her desk. She didn't even leave her office. Warning after warning after warning, she did nothing. The crisis in this case did not begin with the firing of a gun. The crisis in this case began at 11:45 a.m. when Ms. Zwerner initially warned Dr. Parker that there was a problem. That was the moment Dr. Parker should have left the office and investigated what was going on. There is a moment that will be described to you by a witness on the stand, Ms. Zwerner, where after all that she now knows, all the suspicions that she's now heard, and repeatedly she's heard people that Ms. Kovac and others are going and telling Dr. Parker, she sees JT in the classroom wearing the big coat. She's nervous, and if in an instant she sees him pull out that gun and aim it directly at her face. And before she has a chance to do anything but raise her hand up, JT fires that weapon. It hits Ms. Zwerner. At the moment that he fires that weapon, there are 19 children. Right there. And that's why I tell you that this case is not about Ms. Zwerner. This case is about the 19 children whose lives were endangered in that moment, but in the moments before as well. Those children were, some of them, between the gun and Ms. Zwerner. Some of them, a slight movement of the gun could have hit a child instead of Ms. Zwerner. They're right there. Some standing shoulder to shoulder with the shooter. All of them, you'll learn, watched as their teacher clutched her chest and bled before these children, screaming in horror, ran across the hallway to another teacher's classroom, and Ms. Zwerner ran to the office and collapsed on the floor. Where, at that point, was Dr. Parker? She had locked herself down in her office. Was the school on lockdown? Not yet. Still no. But a few minutes after Ms. Zwerner enters the room, a receptionist, Ms. Olivera, does finally put the school on lockdown. I commend her for doing it. She should have had it. And it was too little too late. Back in Ms. Zwerner's classroom, Ms. Kovac has shown up, the reading specialist I told you about earlier. She knows JT. She knows his history. And when she heard that gunshot, she knew exactly what happened. And she went straight into that classroom. She found in that classroom the gun lying on the floor. You'll learn that that gun contains 7 rounds, one of which, 7 rounds plus one that was jammed in the action of the firearm. So 8 that was unspent. Amy Kovac enters that room and she just puts JT in a bear hug as she calls 911. She holds that child there until police arrive. She will tell you that that whole time she was saying, he was cursing. He was saying, explaining that he shot his teacher. And she was saying, like the consummate faculty teacher she is, don't use that bad language. You know better. She's just doing the best she can to control the situation alone in a classroom where a teacher has just been shot. Ms. Kovac, the reading specialist, also the one who searched the book bag after telling Dr. Parker that's what she said. A task that I don't think reading specialists are supposed to do in an emergency. And the reason that I don't think that is because school policy at the time said exactly that. Richneck had adopted a crisis management plan. And that plan required teachers and faculty members to report crisis situations to administrators, and it required administrators to take actions. One such policy from the Newport News handbook, you'll learn, was that in terms of searching a student, that could only be done by an administrator or a school security officer. And at the time of this shooting, there was no school security officer at this building. They shared their security officer with another building, and so the security officer was at the other school. So at the moment of this crisis, there were exactly two people in the building who had the authority under the policy to take action. And those two people were the principal, Ms. Newton, and the assistant principal, Dr. Parker. But let me remind you of how I started today. There was only one person that had both the knowledge of the ongoing crisis and the authority to act. While Ms. Newton, the principal, certainly had the authority to act, she had no idea about any of this. Because Dr. Parker, nor anyone else, bothered to tell her. Ms. Newton, you'll learn, didn't get any of these suspicions that day. She didn't know any of this was happening until there was a gunshot. So she had authority, but no knowledge that there was a problem. It's only Dr. Parker that had both of those things. When you hear from these faculty members, they will tell you that they wish they had violated the policy. In hindsight, there'll be no question. They regret it. They regret following Newport News policy. They will tell you to a person that they wish they had just searched the kid and gotten the gun, or they wish they had just called the police. That's what they say in hindsight. And you know what? I would bet that Dr. Parker also wishes she had done differently. I do. But here's the difference. The policies that were in place enabled, in fact required, Dr. Parker to act. The teachers, on the other hand, and faculty, if they were to act, they'd be acting against the policies that were in place that day. And that is a significant difference. There was only one person in the school that day that had both the authority to act and the knowledge of an ongoing crisis. And that person, you'll see, was Dr. Parker. Many people knew the crisis had begun. Two people had the authority to do something about it, but only one person had both. During the course of this trial, we are going to mention a lot of initials. We're not saying the names of the children because we don't want to put their names out there to let this be their story forever. We're asking everyone that testifies, and all of the personnel will definitely be using initials. I say that because that's going to be a lot of initials. The judge talked to you about taking notes earlier, and it is your choice. These will be distributed to those who wish to take notes here in a few moments. Let me encourage you that that almost all of the important evidence in this case is going to come out piece by piece by piece, puzzled little detail by little detail, from several witnesses who will take the stand and testify. And when you go back to deliberate at the end of all of this, all you'll have is your memory and your notes to help refresh you. You won't be able to have testimony read back to you, as the court pointed out. And often I've had the experience of jurors deciding to ask a question, which is, what did so-and-so say in their testimony? And they are always told by the judge, we can't answer that question. You have to rely on your own memory. And so I'm just giving you that heads up. We're going to be throwing a lot of initials at you, a lot of details at you. And when the judge instructs you on the law at the end of this process, you'll have to remember all those details in order to decide this case. So I do ask you to really pay attention to the witnesses, and I suggest that you take notes to help refresh your own memory, because at the end you will have heard a lot from a lot of different people. January 6, 2023. 20 students went into Ms. Werner's classroom, and their lives were forever changed. The trauma that they experienced is unspeakable, and you will hear from some of the parents about that trauma. That shouldn't happen. And the one person who had both the authority and the knowledge that a crisis was ongoing is the reason that it happened. And we think at the end, the evidence will show you exactly.
Would the defense like to give an opening statement?
Yes, Your Honor.
You may proceed.
May it please the court, Mr. Jenkins, ladies and gentlemen. As you found out yesterday, my name is Kurtish Rogers. I, along with attorney Amy Kovac, are representing Dr. Ebony Parker. Ladies and gentlemen, you have heard that my client, Dr. Parker, is accused of the crime of felony child abuse and neglect. There is one thought that I want you to keep in the forefront of your mind during the pendency of this trial. And that is, based on their actions, there wasn't a gun. Based on their actions, there wasn't a gun. Now, the Commonwealth talks about a lot, and this ongoing crisis, and that Dr. Parker was the only person that had knowledge of the crisis and the authority to act. I would assume that that's not accurate. It's not true. And think about it. Who was the one person that was there from the beginning to the end? And that was the teacher, Ms. Zwerner. Okay, based on her actions, she did not act as if there was a gun present. So if she thought there was a gun present, then her actions should have been to separate the child, in this case JT, from his classmates, or separate the classmates from JT. She didn't do that. There was also another person that had suspicions, and that was Amy Kovac. Okay. If she thought that there was a gun, she had the authority to separate JT from his classmates, or initiate a separation of the classmates from JT. That did not occur. The Commonwealth mentioned that JT was out on the playground with his classmates, and there were teachers, agents of the school, that observed things that were going on, and said that caused them alarm. But based on their actions, they did not respond as if there was a crisis or danger to those students. They did not separate JT from his classmates. They did not separate his classmates from JT. So, Commonwealth is saying that only Dr. Parker had authority. Each one of those individuals had the authority to remove those classmates or to remove JT if they thought that those students were presented with any kind of threat or harm or danger. We're at the beginning of this trial, and I need you to understand that right now, Dr. Parker stands presumed to be innocent. Right now, she's innocent. The Commonwealth has to prove beyond a reasonable doubt that she's guilty of the allegations that they are presenting. The Commonwealth has to prove that Dr. Parker was a guardian or other person responsible for the care of the alleged victims. Before Dr. Parker, there was a teacher, Ms. Zwerner. And the Commonwealth has to prove that Dr. Parker's willful act or omission in the care of the children was so gross, wanton, and culpable as to show a reckless disregard for human life. Who was the person that saw these events from beginning to end? That was the teacher, Ms. Zwerner. Who was another person that pretty much saw everything before Dr. Parker was? That was Amy Kovac, the reading specialist. There was another person that saw everything from definitely before the shots were fired, and that was Mr. Ross. If the Commonwealth wants to accuse Dr. Parker, what about these other people that had direct contact with this child, JT? It is my belief that the Commonwealth will not be able to prove beyond a reasonable doubt that Dr. Parker is guilty of these crimes. And I will be asking at the conclusion of this trial to find Dr. Parker not guilty. Understand, I need you to always consider it based upon their actions. There was no crisis. There was no gun. Based upon their actions, there was no crisis. There was no gun.
Thank you. All right, the bailiff is going to offer you notepads, and then we're going to try to push forward with the first witness. This is the jury handling a break. Okay? And you don't have to take notes, but if you'd like so, we'll distribute notes.